Good morning, everyone. My name is Sophie Sheaf, and I'm here from Employshore in New Zealand. I'm the team leader for our consultancy division here, and I'm really excited to be presenting to you this morning. Thank you so much for all taking the time to sit in this morning, wherever you are in Australia, and I really look forward to teaching you something over this next hour. We're going to do a Q&A session at the end, so please, if you have any questions throughout, make note of them, and I'll happily ask and answer them at the end of the session. And the goal is to really educate you this morning and provide you with some information so you can leave this session knowing a bit more than you did coming in. So getting started, we just want to look at the change of government and how that has impacted the climate here in New Zealand. So, I mean, you're sitting in from all over New Zealand. We've noticed that there has been a change in government recently, which has led to a number of things that we need to prepare for and changes that we need to know about. So the most prominent one of that is that the minimum wage is going to be increasing to $16.50 on the 1st of April. So it's a time to consider at the moment, who do you have on a minimum wage, and also who is potentially being paid below $16.50 that need to be reviewed in terms of their wage rate so that you're going to be compliant come the 1st of April. We've also seen the Labor government increase the paid parental leave from 22 weeks to 26 weeks. And that's going to be progressive up until 2020. So I'm sure many of you have women employees within the business, and it's, I guess, something to consider in terms of encouraging efficiencies within the business, being aware of these, being able to plan for any absences that are going to be there, and just making sure that you're considering those increased entitlements that there will be for parental leave moving forward. There's also been a bit of speculation in terms of what potentially could come about from this change of government. The first topic, I guess, which has a lot of people buzzing at the moment is the removal of the 90-day trial period. And that is something that could affect businesses that have 20 or more employees. So for a smaller scale business that has less than 20 employees, it's unlikely to change. But potentially if you've got over those 20 employees, the government is potentially looking to remove that 90-day trial period. Now we're going to talk a bit more about trial periods in a few minutes, but I just want to make sure that, you know, trial periods, if they're used really well, they can of course be extremely useful for the business in terms of trying people out. But also, you know, our whole goal here at Employshore is to help our clients, and no matter what that legislation looks like, there are going to be ways that we can potentially work with our clients to still ensure protections if that 90-day trial period is removed, and talk about strategies to ensure that there's less impact on the business if that was something that does come into effect in the future. In terms of having a collective agreement in place, we're looking at potentially there being an introduction of fair pay agreements and increased powers of unions in the workplace. So, for example, there might be union representatives that can go into the workplace without notifying the employer. There's talks of having employees on a collective agreement for their first 30 days of employment, and then deciding if they want to go on to a collective agreement or an individual employment agreement. So it's really a consideration to have if you know anyone, obviously, that have collective agreements in place, or if you have collective agreements in place yourself. We're definitely looking at that potential change and ways that we can strategize with our clients to make sure that they're obviously not very affected by that change, and find solutions for any issues that could arise. Lastly, a change to be prepared for is we're likely to see a doubling of labour inspectors to 110 people nationwide. Now, labour inspectors, for So some of you that may not know obviously can go in and give you an on-the-spot fine for any non-compliant employment agreement. If you don't have an employment agreement in place with an employee, because a written employment agreement is required by law, they can also give you fines for underpaying workers, not paying them their holiday pay correctly, and so on. So seeing an increase in their representation is probably likely to see a few more fines, being handed out, and just a potential more risk for small businesses that potentially are non-compliant at the moment. So we work pretty closely with labour inspectors at Employshire, and they love us. They love the work that we do, heading out to ensure that businesses are compliant. So we have a positive relationship with them, and quite often if they see that we're on board, they treat the employer a little nicer than they normally would. So obviously just a few things to be aware of, and I can touch on a few more as we move through the slides. The main things we want to cover off today obviously are employment agreements, policies, and the health and safety obligations. So this morning we are going to start with the employment agreements and how essential they are to be in your business. I've seen about 200 clients to date, and a lot of the time, business owners don't necessarily know what they don't know. Number one being that you do need to have a written employment agreement in place for all your employees. That includes your casuals and any type of fixed term agreements, as well, volunteers. So I guess the main reason why agreements and policies are so important are to manage that risk. I just spoke about the labour inspectors and how they can come in and give you a fine. We have incredibly complex legislation in New Zealand, and part of the Employment Relations Act states that it's a mandatory requirement to have that written employment agreement in place. Obviously, the agreements, they create certainty between the employer and the employee, and they create protection for the employer in the event of something to occur, and obviously protection against any claims, because quite often, if you've got your mandatory requirements within your employment agreement, there's going to be a process that you need to follow, and it will be entered in good faith, and that way you're in a much better position than working off an implied agreement. Employment agreements and policies also help manage your employees. Quite often we encourage having employment agreements quite brief and fleshing out policies in a separate employee handbook, and that allows you to really set expectations with the employees and actually set up processes to enforce those expectations. A key example for that is something around sick leave, having a clear policy in place for someone who's sick, that one, they have to phone in, they can't message or email. Two, they have to provide a medical certificate if they're sick. And three, they have to conduct a return to work interview. By simply enforcing that three-step process, we've seen this with a lot of our clients. It's actually really increased the morale and the efficiency in the workplace. They've had that policy in their handbook that they can rely back on, and if they're consistently enforcing that, they actually see this increase in productivity and efficiency. They have more people at work, less people just calling in sick when they're hungover. Because there's a pretty common perception in New Zealand, I think, that your 5 days sick leave and almost seem to believe that they're 5 days of annual leave. So a lot of business owners I speak to, have issues with managing sick leave. And whilst obviously you don't want to have people in the workplace that are sick, that's where that return to work interview comes in really key, because you can obviously make sure that that employee is fit and able to be at work. And if they're not, sometimes you have these workaholics who just want to be at work and they don't want to leave. That actually gives you a bit of an ability to say, hey, from a health and safety perspective, we need to take into consideration how you're feeling, what your doctors have said, and probably best you have the day at home today. So some really key considerations, and I'll give you a few more examples moving forward, but we've seen that be really successful for our clients at the moment. So I just wanted to talk about the key features that need to be in employment agreements. It's very common that I'm going into businesses that actually haven't updated their employment agreements as of April 2017. So not only the legislative changes that I spoke about through the change of government, but we saw some key legislation changes come in that were effective as of April last year. So that was around availability and as well around shift cancellation. So I use this buzzword availability, which I want to kind of explain in a bit more depth. Basically, we saw a removal of 0-hour contracts. So you guys might remember, McDonald's was in the press for requiring employees to be available just to work kind of willy-nilly hours. There was no guarantee of the employee when they were actually going to be required to work. So it's very common that I look at agreements that haven't been updated after that period that still have in a waged agreement, you might be required to do additional hours. There's really been a change in how that now needs to be drafted. If you are requiring an employee to be available beyond the guaranteed hours in their employment agreement, there needs to be an availability clause, giving them compensation for being available, and actually stating a reasonable amount of time that you would want them to be available for. As well, that means that there does need to be guaranteed hours within an employment agreement, which we have seen is quite difficult, for example, for our clients that work outdoors, for example, or have seasonal work, and their hours might change from week to week or season to season. And we definitely work closely with our clients to navigate ways to still have a compliant agreement, but reflect that within their guaranteed hours clause. So you've got your set of mandatory clauses. The key thing is as well, you want to set out what type of employment it is. So there is a difference, between a permanent employee, between a casual employee, definitely between an independent contractor, a fixed-term employee. So, it is important to kind of understand, what is the nature of the relationship, and has that nature of the relationship changed since you put your original employment agreement in place? So a lot of, business owners potentially might start someone off on a casual agreement, and then down the track they kind of morph into a permanent employee. So a lot of the time our consultants are going in and actually analysing what that working relationship looks like at the moment. Has there been any changes? And, what actual type of employment are you wanting to reflect in your employment agreement? So I've touched on the kind of hours of work and wages. I'm not going to go into too much depth about availability. It is quite a technical term, and it does differ for employees on salary versus employees on wages. So there are ways to capture availability through a salaried employee, and potentially within those agreements, if someone's on a high enough salary, you can actually require them to work reasonable additional hours without further compensation. So quite often that's a tactic we talk with our employers that we represent. Key things to really have in your employment agreement as well, obviously around intellectual property and confidentiality, termination grounds and notice periods. So that will come into what we talk about next in terms of trial periods. But really key to consider what termination period you currently have in your employment agreement. Does that need to be reduced, or does that need to be increased depending on the size of your business and the need to have people if someone was to leave? And as well, there's a common issue around post-termination obligations. Would you want to have a restraint of trade in place for your employees is always a key consideration to have. So just wanted to touch on trial periods and really how to use them correctly. This is an area where we see a lot of non-compliance. The key things here is that they can only be used for new employees. So if you know that employee, they've worked for you before as a casual or as an independent contractor, the key thing is you wouldn't be able to put in a trial period in their agreement most of the time. And they really have to be a new employee who you're unfamiliar with. As well, there needs to be a valid clause. So a lot of our existing clients potentially have had agreements that they've got off the internet in the past. And unfortunately, there have been government websites that have actually incorrectly drafted trial period clauses. So we are dealing with a big issue at the moment, unraveling all of those claims. But making sure you've got a valid trial period clause is also very key. The main issue is when employees start and they haven't signed their agreement before they actually start work. So whether that be, the day they come in for some training, or the day that they're the first day of work, if you're getting their agreement off them, even an hour after they've started work or a week later, it's unlikely that that trial period is going to be valid or be able to be upheld if there is a claim. So we want to really stress having those agreements signed and returned prior to that new employee commencing work. Obviously, you need to enter the trial period in good faith. They need to be aware that there's going to be a trial period placed. And there's been a bit of contention at the moment around payment in lieu or garden leave when you're looking at terminating an employee. So it's just something to be aware of, and always seek advice when you are wanting to terminate an employee over the trial period. At the moment, the case law is leaning towards putting those employees on garden leave rather than paying them in lieu of notice. I'd always suggest reach out and seek advice in those instances. So I next just want to touch on policies, and we've kind of touched on them already in terms of why they're so important. And I guess that key difference from an employment agreement is that employment agreements are legally enforceable, whereas your policies can contain more of your discretionary terms, and they can actually be amended without the employee's consent. Every time you amend a employment agreement, you need to get that varied and signed by the employer and the employee. So quite often we put the bulk of our policy into this policy handbook, because it means you can amend policies without getting the employee to sign. So a really good example might be a vehicle policy that sits outside of your employment agreement. You might have some instances that happen within the business where you want to actually update that vehicle policy. Maybe there's been a theft and you think, oh, let's outline that in our policy in terms of who's going to be liable if there is a theft of a vehicle. And that gives you the ability to change the policy, let all the team know, without having to go through that sign variation each time you want to make a change. And I think, quite often when I am looking at employment agreements, I do see very policy-heavy employment agreements in place. So as I said, we like to really strip that down, put everything necessary in the employment agreement, and then we've got the kind of key policies sitting in that employment handbook. It allows you as well to morph with the times. Quite often, their business might grow, or they might want to implement a new system, and it gives you flexibility to draft that into your policy. I gave you the example before around leave. Another example there is people taking annual leave or holidays. Do you have a policy in place at the moment where they have to give you notice before they take that leave, or a process in place in applying for leave? Quite commonly I see clients who have issues where employees have booked travel and then applied for their leave. So having policies in place to really preempt any of these type of situations and give the employer that protection to come back to the employee and kind of negotiate around these issues. Again, we've got a lot of companies now who issue out computers or mobiles, or they might be using company property. Do you have policies in place protecting the use of that property? Do you have policies in place around conduct? Social media is a huge thing, especially coming up with the younger generations, and also a lot of businesses having more of a social media presence. So, if you've got employees in uniforms, are there policies in place where you're actually making sure that there could potentially be disciplinary action if they've got Snapchats online with their logo T-shirt on them? So making sure you're kind of preempting any of these situations, so you have these policies in place to protect you. Health and safety is a big one, and also having processes in place in terms of disciplinary action and performance management, all will really help you if you ever are going through these issues. And a lot of the time it's better to preempt these issues from happening, have them in your policies. A lot of businesses come to us and say, look, we've never had an issue, and that's absolutely fine, that's fantastic, but we want to preempt any of those types of issues happening and make sure that there's a safety net in place. in the event, touch wood, that any of them do. So that's a bit about your health and safety, that's a bit about your employment agreements and your policies. And please, if you've got any questions around that, feel free to type them away before we touch on health and safety. I just want to really encourage you, I can answer those questions at the end of the session. And I know that there's probably a lot of information to take in, so always a lot of questions come out of that part. But we have seen, obviously, the introduction of the Health and Safety at Work Act in New Zealand. And it's really key that as business owners or as key personnel in businesses that you are aware of what those obligations are. So at the moment we have the Health and Safety at Work Act, which is obviously a mandatory requirement for businesses and employees and workers to comply with. And we've got also a set of mandatory regulations that aren't yet incorporated into that act, probably likely to be down the track. We're following a lot of what the legislation looks like in Australia today. We're really lucky in that we can build on the wealth of knowledge that we have from our colleagues in Australia and actually provide our clients with top-end resources. I've noted there around the codes of practice. These are usually advisory materials that we can use to help inform the way that we best implement health and safety within the workplace. So, for example, you might have a code of practice on safe stacking in the workplace. A lot of these codes of practice at the moment are quite out of date. So, as I said, we look to our colleagues in Australia. They've got a lot of up-to-date resources over there, and quite often we're actually preempting what those new codes of practice are going to look like in New Zealand, and we want to be ahead of the ball mark when we provide our advice to clients. So, me and the consultancy team, we really pride ourselves on giving super up-to-date information and also utilising guidance materials and the New Zealand standards to help inform our clients and owners of what their obligations are with health and safety. There's definitely been a shift from the Pike River mine as to, directors can no longer sit in the room and be completely oblivious to what's going on within the business. There's now this added responsibility for the businesses to be doing everything reasonably practical to ensure the safety of the workers in the business. And that really is a duty of care. So when we talk about a PCBU, this is a person conducting a business or undertaking. I did reference business before, but it also includes people getting undertakings. So, that can be a non-for-profit organisation as well. And the PCBU is looking more at the entity or the company franchise. It could be the employer as a whole or the contractor or subcontractor or business owner. That's the key person within the business. There's also then the officer that has these responsibilities. So they are usually the people involved in that key decision making of the business. Quite often they are making their significant financial decisions within the business. And that extends to board members, directors, company secretaries, partners, and CEOs. So as I said before, the directors do now have to be very involved within the business and know what's going on in terms of health and safety. They need to be part of that consultation process with the employees and with the other officers in the business. So we've got the interplay of the PCBU and the officer. There's also obligations of the workers. So quite often I'm going into businesses and they're saying, oh, look, I keep trying to tell this employee to put their personal protective equipment on, and I just won't do it. So, provided you have a really good health and safety system in place that sets out the responsibilities of the business, it sets out the responsibilities of the officer, and it also sets out the responsibilities of the worker. A worker is an incredibly broad definition as well. It's basically anyone on site that's working, which can be a volunteer, it can be an independent contractor, it can be an employee. anyone that's basically working on the site. Now, if they are not wearing their personal protective equipment after directions being given, that's where the kind of, tying it back into the policies and the employment agreement and having those avenues of disciplinary action to ensure that there's a consistent message being given to the workers in the workplace and make sure there is kind of repercussions of those actions. Because at the end of the day, it does say that the businesses need to be doing everything reasonably practical. So if you can show, through your meeting minutes that you've informed everyone to wear their personal protective equipment, through your corrective action plans, you've been telling people and informing them to wear that personal protective equipment. It's in your health and safety management system. They're briefed on it in induction. There's been constant follow-ups and consultation. If you can show you're doing everything reasonably practical and are still not doing it, that potentially could lead to a fine for the actual worker. So, when looking at this slide, and I don't like to spend a huge amount of time on it because it is quite daunting for business owners. The penalties for the health and safety breaches now are very significant. We've basically seen a move in the decimal point in terms of, what used to be a $300,000 fine for a business now could be up to a $3 million fine. And it's pretty hefty, seeing as this health and safety legislation is a criminal piece of legislation. So we are looking at criminal offence. So that's either fine or imprisonment. And what I really like to enforce here is, look, if you're doing everything reasonably practical, if you've got written records of everything, you're keeping paper trails, you're doing your risk registers, you're inducting your staff, you know that everyone's competent to be doing their job. Accidents will happen and, that liability will shift if you can show you've been doing everything reasonably practical. Where we've seen fines under this legislation most recently is where businesses have been aware of a defect in a piece of machinery, for example. They've kept using that machinery knowing there was a defect, and then there's been an injury, like an amputation of an arm or something like that, which it's very tough. And that's where businesses become liable if they know of a risk in the business and they've done nothing about it. And you can see the different categories there in terms of if there's serious injury and if they were reckless in terms of knowing that there was going to be a risk in continued work. So a lot of the time that could come down to the competency of the actual worker and ensuring you have a health and safety management system in place that everyone's really engaged in. We've got that constant consultation. Ultimately, health and safety management systems are put in place to protect the workers in the workplace. And if you did face a fine like this, it's significant. It could put a business out of business. So I think reassuring the employers that and the employees that this system is to make sure the business is more efficient, to make sure people are going to be working safely, to make sure you've got jobs at the end of the day. There's nothing worse than kind of going through an injury or a death in the workplace. It has a huge effect on morale. So we're constantly trying to equip our clients with the best possible resources to prevent any type of breach happening. We've recently seen a change in the hazardous substances regulation. This has now been incorporated into our health and safety legislation. So basically it means, I quite often, if I'm in a room of people, will say pop up your hand if you've got hazardous substances in the workplace. And this can come right down to a cleaning product. So, it's good to be aware of what is a hazardous substance and, how have these obligations changed and what now is required of me. So in terms of having hazardous substances in the workplace, you now need to make sure that everyone's trained to be using those hazardous substances and there's ongoing training. There also needs to be an inventory of hazardous substances and they need to be labelled appropriately. There was a terrible case that actually happened in Australia whereby a hazardous chemical was decanted into a container of Coke, and there was an unfortunate event where a worker actually drank out of the Coke bottle and was poisoned. So the labeling of the chemicals is so important, especially if you're changing them from containers, making sure everyone's super aware of how it needs to be labelled appropriately, and there's a lot of information out there on how that can be done. Safety data sheets are now a requirement, so you do need to have a safety data sheet in place for all of your hazardous chemicals in the workplace, and you need to make sure that the workers are aware of where those safety data sheets are kept, and they're aware of the content within those safety data sheets to make sure they know the ingredients within the substance, how to deal with it in the event of an emergency, and so on. You also do need to have a spill kit in the workplace. So you've got to consider how much of hazardous chemical you have in the workplace and what would be a reasonable spill kit to have in place. If you've just got a few containers of chemical versus, big tubs and gallons of chemical, the requirement on that spill kit is going to be quite different depending on how much substance you're holding on site. So I hope you found that discussion around health and safety pretty useful. I just wanted to touch here on the service that we provide in terms of health and safety, and as well as employment relations. Typically, if you do sign up with our Employee Sure service, we have a consultant that comes out and meets you at your business. We call that meeting your compliance meeting. So we look at what's in place at the moment, your existing policies, your existing agreements. Maybe there's no policies and agreements in place at the moment, so we discuss, what those relationships look like at the moment and what we can put in place to ensure you're compliant moving forward. From a health and safety perspective as well, we do a review. We look at the types of activities being carried out on site, the key hazards on site, and immediate risks. So that consultant spends a whole day at the business. The first couple of hours are spent really gathering information, and then they go away, they draft some documentation and do a wrap-up with you in the afternoon. The consultant is going to work on a suite of documents for you, which includes the review letter and action plan. If you're with us for employment services as well, that will include all your employment agreements and handbooks and covering letters. And from a health and safety perspective, that's a whole health and safety manual and handbook and any supporting documents and forms that you need to kind of put those written obligations to ensure that you're compliant under the legislation within a manual, within a handbook. It's very hard to kind of show that you're compliant with the Act without having that health and safety manual in writing. And I just, I encourage it so much in terms of being able to display exactly what the obligations of each party are in regards to health and safety. After about 2 weeks after your compliance meeting with your consultant, they run an implementation meeting with you where they talk about how to implement the documents into the business, strategies on how to do that. A lot of the time there might be a few questions that come up and actually talk you through all the different documents that they've provided and how to implement those into the business. There's also a follow-up done a couple of weeks after that, and obviously a consistent review of your documentation. We do have an advice team which are incredibly amazing, and any ongoing amendments that you want to your document, that can be done just through calling through to our advice team. So speaking of our advice team, I just wanted to briefly explain the actual service that we are providing. Obviously, our aim is to really ensure safe workplaces. We want to make sure that businesses are complying with the legislation. Sometimes that means that, first of all, they need to know of where those gaps are, how that they're complying at the moment, and potentially where there's an area of non-compliance. And that's really our first tier of the service, which is that meeting with a consultant where they come out and do that complete workplace review and set you up with documentation that's compliant that you can implement moving forward to avoid any risk of non-compliance. From the day that you sign up with our services, you also have access to our advice line. That's a 24/7 service. Outside of business hours, there's just a callback service, but we do have people on the phones all the time providing advice, and they really act like another employee of your business. I say, you know, call them about anything, big or small. We record all of our notes on our system, we record all of our calls, and quite often we have case files on all of the employees. So, you know, if you're dealing with a particular employee, we can go back and see any type of action that's been taken against that employee or any concerns that you've had with that employee, and really work on strategies and getting issues resolved, and also providing any documentation along the way that you may require, reviewing any documents that you would like us to, and it's just, you know, such a valuable part of our service is that constant access to unlimited advice. We really put our money where our mouth is in terms of the advice that we give. We offer insurance in respect of that, so we insure the advice that we give, so provided our clients are following the advice that we give, that is covered. If anything is likely to go wrong, we actually step in and pay those costs and ensure that the client's represented moving forward. So it's an extremely comprehensive service, and, you know, been extremely successful to date. I mean, we've grown almost at 3,000 clients in New Zealand, which is a phenomenal result over a 2-year period. So it's been very exciting to be part of that Employ Sure journey. Now, I really hope that you've found what I've spoken about this morning useful. It's just a brief kind of update as to what employment relations changes there are going to be. And hopefully you've taken something out of the session this morning, and maybe once we take a few questions, you might even have a few more answers. But I just wanted to take this opportunity to let you know that we do have workplace consultants available to come out and see you free of charge after this seminar this morning. There'll be someone getting in touch with you. So hopefully, you know, if this really resonates with you and you would like our assistance, or just like them to come out and see your business, how it's operating, and potentially understand how we can be of assistance, I really encourage you to meet with one of our consultants for that time. Awesome. So I think we might do a bit of Q&A now. I'm going to have a look at the questions that have come through. So I've seen one here. If you get someone to work when needed, only like scanning files, do you need an employment agreement? I think the key thing here is anyone performing work as an employee and being paid by the business, there is that obligation to have a written employment agreement in place. Some of these questions probably will require a bit more context, I guess, but there is that legislative requirement for any employee within New Zealand to have a written employment agreement in place. Now, it's slightly different for an independent contractor. There's no obligation per se, but we always encourage having something in writing with an independent contractor, because that's a really grey area at the moment, where we see a lot of independent contractors being engaged incorrectly where they should be permanent employees. And if you do have independent contractors within your business, I highly recommend you reach out and speak with one of our consultants so that they can kind of highlight any areas there potentially of risk. So another question here, if you get someone under 18 still at school to work after school just for 1 hour per week to do the rubbish tidying up in the office, do you need an employment agreement? Do you need to pay him or her the minimum wage? Again, I think this speaks to the question that I just answered in terms of there does need to be an employment agreement in place. If they are under 18, there is a training wage that is available, or, you know, in this case, I would probably recommend that you do get advice in the specific circumstance. Quite often people think, oh, they're just working 1 day a week, they're a casual employee. But you can still have an agreement in place for just that 1 hour a week. It doesn't have to be hugely comprehensive. But at the end of the day, if that's an ongoing relationship, that really does need to be put in writing. And I would be looking at, when are they going to be turning 18? My understanding is anyone over the age of 16, you want to be paying them at least minimum wage and being aware that minimum wage is about to increase as well. I've just seen another question here. Is there any minimum hours you can have in a permanent part-time contract? So I think there is that difference between a permanent part-time and a permanent person. For example, if they are a permanent part-time, I would say there's no necessary minimum hours. I'd say probably 1 hour would be your minimum amount of hours that you can provide. Again, it's good to have some context around these questions and kind of understand exactly what type of work that person is performing and taking into account, obviously, are they traveling far for work, and what other considerations need to be taken into account. So again, that's a good example of an issue that our consultants will work through you with. But as long as you have those guaranteed hours in the agreement, unless you are engaging someone on a casual basis, you don't actually have to state your guaranteed hours. But then there's the question of, are they a true casual? Is there no guarantee of ongoing work? Are they being paid their holiday pay on top of their wage? Another question here is, what is the process if you need to change minimum hours from 24 hours per week to 16 hours per week due to work demands dropping? Now, I think this is a common issue that a lot of businesses face, and we have to be very aware here if you are reducing someone's entitlements to wages, that there can be potential claims of disadvantage. That really needs to be a fair consultation process, and I would definitely be getting advice before you do any type of change within that agreement, and making sure that particular process is followed. We have such a clear process that needs to be followed within New Zealand, and unfortunately a lot of businesses risk being privy to a personal grievance when even one aspect of that process isn't followed. So you do really need to seek advice on and following that process, and of course making sure that you're not going to put the business at risk by the process that you go through. I've seen another question there. How much notice should the employee give you if they require leave? This is really up to the business. I commonly recommend 4 weeks notice if they're going to take a week or more off, and a week's notice if they're going to take the odd day, and obviously the business has a discretion there. I also, it's going to depend on the size of your business and the ability you have to fill that space while someone's away. So a smaller business may require a longer notice period, but you've also got to think, what's reasonable, and that's always a conversation we're having with our clients too. Just another question here is, we frequently require temp teaching staff to cover absences. Are these staff required by the agency, or do I need documentation for health and safety whilst in my childcare? So I'm just going to try and unravel that question a bit. It sounds like this employer brings in temporary staff from an agency to cover people when they're absent, and do they come under the health and safety requirements of the employer, or are they covered by the agency? This is a very grey area as well, and again, I'd be wanting to get a bit more facts in terms of what exactly is going on. I think the key thing here is anyone who's performing work in your workplace would need to be inducted into the site and need to be aware of what your health and safety policies are. So a kind of general answer here is that potentially that health and safety management system that you have in place could be sent to the agency, and you need to negotiate with the agency and make sure you have an agreement as to who will be responsible for what in terms of health and safety. So, who's going to do that induction, make sure that they're aware of what the health and safety obligations are while they're on site. I think you also need to consider as well that employment relationship, and it's going to depend on who is playing that temporary worker. Another question here. Could you touch on the trial period under the new regime at companies with over 20 employees? How is that going to be enforced by the new government? And what are the alternatives for companies with over 20? Now, we did touch on this at the start. I think there's a bit of misconception at the moment that this has actually come into law. At the moment, it's still in speculation. So I think until there's anything passed, we're actually unsure of what exactly it will look like. At the moment, there's just a lot of speculation going around that for companies with under 20 employees, that trial period will still be in place, and potentially for companies that have beyond 20 employees, that trial period will be removed. And I did kind of mention at the start that, we can kind of, if that trial period is to be removed, we can look at strategies such as probationary periods and other ways to provide protection for employers. All right. So I think I've touched those all off. I really appreciate your guys' questions, and obviously, if you've got any questions, we've also got that opportunity to meet with someone from Employee Shore and discuss those in greater depth. I know it can be a bit tough sometimes over the web, but really appreciate those questions, and I'm going to hand it back to Redback now.
Thank you, Sophie, for your presentation, and thank you for everyone for attending the webinar. If you haven't done so already, please fill out our survey, which is on your screen now. We thank you in advance for your feedback and wish you a great afternoon.